provision of the Companies Act also prescribe for the date, time and venue on which the meeting is to be held. An annual general meeting can be held on any day except the national holiday. Here by national holiday we mean that day declared as a national holiday by the central government. It can be held during the business hours, that is 9 AM to 6 PM. And such meeting can be held either at the registered office of the company, and where the registered office of the company cannot accommodate a vast shareholder base, then it can be held. The meeting can also be held at some other place within the same city, town or village in which the registered office of the company is situated. Section 102 enlists various businesses which are to be necessarily transacted at an annual general meeting. Such items or businesses are called as ordinary businesses. That is why sometimes an annual general meeting is also called as an ordinary meeting. Such items which are to be transacted at annual general meetings include: number 1, consideration of financial statements, board reports and auditor reports of the companies, declaring dividends if any, appointment of directors of the company, and appointment and fixation of salary of the auditors of the company. Besides these 4 items of ordinary business that are to be transacted at annual general meeting, all other businesses which are to be transacted are called special businesses. All other meetings, if it is required to be convened and held of all the members of a company, then it can be held as an extraordinary general meeting. One meeting is to be held as an annual general meeting in each year, and in case the company requires to hold and take such other decisions which requires the assent of the members, then in those cases an extraordinary general meeting of the members can be convened and held till the time the next AGM is held. All business transacted at an extraordinary general meeting are considered as special businesses. Like we discussed, all the businesses besides those which are stated under section 102 are to be treated as special businesses. So, all those items can be dealt at extraordinary general meetings. These extraordinary general meetings can be called by the board of directors. It can also be called by the board of directors on a requisition being made by the shareholders of the company, or in case the board of directors fail to hold such meeting, the shareholders who are making requisition can also go about holding the meeting, the extraordinary general meeting themselves, and in certain cases the tribunal can also call such meetings. The shareholders who are making this requisition for holding an extraordinary general meeting must possess at least 1/10 of the paid up share capital of the company, and where the company is without share capital, in such cases those shareholders must possess at least 1/10 of the voting powers of the company. Only this much shareholding or the voting power must be held, that is 1/10 must be held by the shareholders who are desirous of making a requisition to the board for holding an extraordinary general meeting. The board of directors, when they receive such valid requisition, a requisition of the shareholders is considered as valid when it is in writing and is signed by those members who want such requisition, must call the extraordinary general meeting within 21 days, and the date of meeting in any case must not be later than 45 days from such requisition. They must call a general meeting upon receipt of requisition. The board must call the extraordinary general meeting within 21 days, and the date of meeting must not be later than 45 days from the date of receiving such requisition. In case these deadlines, that is 21 days and 45 days, are not met by the board of directors, the shareholders making the requisition for such meeting may go ahead to call and hold shareholders meetings themselves. They can do so within 3 months from the date of requisition of such meeting. All the reasonable expenses which are incurred by such requisitioning shareholders for holding such meeting, like the registered office, for holding such meeting, notices are to be given, everything, whatever expenses, reasonable expenses they make, are to be reimbursed to such members by the company. Such reimbursement is made by the company by deducting such amounts from the fees of the defaulting directors, the directors which could not make the meeting held within those deadlines. There have been numerous judicial pronouncements in this regard, like in LIC of India versus Escorts Limited. The Supreme Court observed that every shareholder of a company possesses a right to call or to give a requisition for an extraordinary general meeting subject to the provisions of the Act. Once the requisition is made in compliance with the provisions of the Act, the shareholder cannot be restrained from calling such meeting. Also, in R. Chettiar versus M. Chettiar, the shareholders gave a requisition in compliance of the provisions of the Companies Act for removing the managing director of the company, whereby they wanted to call an extraordinary general meeting. The directors failed to call such meeting within the prescribed deadlines with time period. The shareholders then went about calling the meeting on their own. The venue of the meeting was decided as the registered office of the company, and on the day of the meeting it was found that the registered office was locked. Thus, the meeting was to be held at some other place besides the registered office. The court held that such a meeting was validly convened. In certain cases, the tribunal may, under certain circumstances, order to hold and convene an extraordinary meeting, where it can do so. The tribunal may do so on its own motion or upon receiving an application by the directors or members having the voting rights to call an extraordinary general meeting. The tribunal may give necessary directions to conduct the meeting, including the permission for holding one person meetings or through proxy. There are certain requisites of holding a valid meeting. As we stated, that in order to convene a meeting or hold and convene a meeting as prescribed under the rules of the provisions and the rules of the Act, these requisites are to be complied with in order to transact a valid and binding business for the company. Notice of the meeting is required to be served to every member of the company, directors of the company and auditors of the company, either in writing or through electronic mode, that is through emails. The notice is required to be served at least 21 days prior to the date of the meeting. However, the meetings can even be called at a shorter notice than of these 21 days if 95% of the members agree to such shorter notice for a meeting. The notice must also provide for the date, time and venue of the meeting, along with the agenda of the items which are proposed to be transacted at such meeting.